Good afternoon, and thank you for joining us for this exclusive ICE webinar for our ICE clients. It is 1 o'clock exactly, so we will get started. So like the invite said, this is the ICE webinar for tips and tricks and all of the fun ICE stuff that we will be talking about today. Our presenters are myself, Kelly Dempsey, the Director of the ICE Services, and I have with me Jen McCormick, our VP of Consulting. Jen, I don't know if you want to say hello. Just make sure your speaker's working.
Good afternoon, everyone. Thank you so much for finding the time to join us today.
All right, great. So we will get started, and I will have Jen kick it off with a little intro.
Great. All right. Thank you very much, Kelly. Okay, so before we dig in a little bit more about ICE, just wanted to take a quick opportunity here and do a quick refresher of the different pillars of how SIA can assist. So while the focus of today is the different opportunities, questions, tips and tricks and things that we can assist with under ICE, we don't want you to think that our opportunity to work together or to assist is solely limited to those consulting questions or those different drafting assessment type projects. So in addition to all of the different ICE items that we can assist with, there are other opportunities that we can work together under our Plan, Save, and Protect umbrellas. So specifically when it comes to plans, so if there is a particular question that is going to involve, it starts with an ICE question and you realize that maybe there's an opportunity that you'll need some assistance in actually creating a new plan or revising some actual plan language. It's not that we can't assist with that, we can. It would just be under the plan umbrella as opposed to the ICE umbrella. Next, when it comes to our SAVE umbrella, that's where we talk about subrogation and our recovery services and CNS and our provider relations services as well. So if there is a particular circumstance where maybe you need some assistance negotiating a claim, or you feel like there's maybe an opportunity for the plan to recover some funds that may have been paid by the plan when they should have actually been paid by an auto insurance carrier, even if those are not necessarily projects that can be handled under ICE, we can certainly still handle those under a different umbrella. And last but not least is PACE and our balance billing defense. So just in brief, our PACE services where we're taking on some fiduciary responsibility, the transfer of that fiduciary risk when it comes to second level appeals. So that is something that we can assist with too when it comes to those particular questions, but just know that's a little bit separate than ICE. So if there's questions about any of these or how something can lead from ICE to another area, please feel free to reach out to us and we'll be more than happy to assist with any of those questions. All right, so let's talk about today. What's the agenda for today? So there are kind of three main topics that we're going to dig into that we want to discuss in a little bit more detail, how the opportunity to get some feedback from everyone about the things that we've done. We really want this to be an opportunity for people to realize what exactly do you get with ICE? What is it that we can do? So what does ICE provide you? What are the opportunities that you can reach out to us, ask us questions, get our input, get feedback potentially on a strategy or other considerations that might be relevant for a particular matter that you're dealing with internally. Also, what are we doing the most? So what are the most types of questions, frequently asked questions that we're getting? Is there a giant umbrella of the majority of the ICE questions that we're seeing are under this umbrella versus that umbrella? We'll share that information with you so you can get an idea about how others are utilizing ICE as well. And last but not least, we're actually going to give a couple of examples, real-life examples of how we've been able to assist some ICE clients. So projects or questions that they had run into, what were those examples, how did we assist, and also we're going to end by going over a couple of tips and tricks to keep in mind that might be relevant for you if the situation arises in the future. So with that, Kelly, why don't you dig in a little bit about what ICE actually provides?
All right, so for those of you who don't know, I would assume all of you do at this point, ICE stands for Independent Consultation and Evaluation. This is our general consulting service where we have a whole bunch of different topics and things that fall underneath this large umbrella. So there's three kind of main buckets of services that we'll go over again quickly for those of you who need a quick refresher. So the first is our federal and state law compliance and regulatory consultation. This is probably the broadest area of the ICE service because there's so many different things that can fall underneath this bucket. We've got ERISA questions like ERISA preemption over state law, fiduciary duties under ERISA, reporting and disclosure requirements. We've got questions about HIPAA, data privacy regulations, and non-discrimination. This can be a big topic for those, especially those maybe joining a captive or moving from fully insured to self-funded who've never been self-funded before. They have a lot of questions because it's different in the self-funding space of what data you have access to. And there can also be other, procedural questions under HIPAA that may be different for those that are in self-funding. COBRA is another big topic. Obviously, it's a big law. It impacts our industry in many different ways. It's a very procedural-based law where there's a lot of specifics regarding timing of notifications and offers of COBRA and when COBRA can terminate and so on and so forth. So it's very important to be aware of all the procedural issues that can happen with COBRA and kind of go sideways if something is missed or not sent timely. ACA has obviously been one of our favorite topics to talk about for the past 8 years, and it's never a dull moment as things continue to change over on Capitol Hill. So right now, a lot of the ACA questions we're getting are regarding certain notice requirements, especially with mid-year plan changes and how that impacts SBCs. Employer mandate rules are still a big issue, even though the mandate's been in effect for a couple years. We've started seeing a big uptick in the penalties that employers are getting. We're seeing a lot of employers getting letters saying that they owe the IRS substantial amounts of money. We've seen anywhere from $40,000 to actually over $1 million in penalties in these letters. So if you get those types of questions from your clients and you need some help, we're happy to help guide you down the path of how to best respond to those. Still getting questions about essential health benefits and 1557, especially in light of the injunction and other things that are happening in the 1557 space. We also get a lot of questions about FMLA and leaves of absence. This can be very heavily relied on what's in the plan document and what's in your handbook, and we'll dig into that a little bit more on the next slide. And then obviously, everybody's favorite topic of IRS regulations when it comes to high deductible health plans and all the special rules that come into play with those types of plans and how they deal with HSAs and then subsequently FSAs and HRAs that are all carried into that bucket and how they all interact.
Great. Okay. So just as a quick note too, before I dig into this, I do want everyone to feel comfortable that they should be sending us questions or concerns about any topic that sort of arises, if it relates to the plan or relates to benefits, and even if it's not necessarily something that we can provide with a specific answer to, we can at least provide strategy or feedback on those types of issues, questions, and particularly when it comes to the claim review and the plan act assessments. So there are a laundry list of items under this section of how ICE can be helpful in the services that we provide under that umbrella. So the first is the ability to assess some sort of claim or exclusion issue against the relevant plan materials and the stop-loss policy, or actually any other agreement that might be relevant based on the particular situation. So this is not PACE, where we're taking on the fiduciary responsibility for making a particular claim decision, but it's very common for there to be circumstances where you have some plan language and you have a particular circumstance where you're not sure whether a claim, maybe there was some drinking and driving or drugs that had been involved or some other particular fact pattern, and you're not sure whether or not that would present a exclusion issue or a payment issue under the actual plan terms. And you're looking for another opinion. So for that common example, we encourage you to send those claim analysis type questions to FIA. We'll need obviously a copy of the plan materials, if there's police reports, anything that would substantiate whatever fact pattern or issues that you're actually questioning or the group might be questioning of the plan. So with that information, when it comes to the plan materials, we can review the relevant language, provide an interpretation based on the facts that were presented and how the plan document reads to us, and provide that analysis back to you and back to the group to decide how those claims should be processed. And to take it even one step further, we have the opportunity, if we're provided for example, the stop loss policy, to take a look at the actual situation and look at the actual stop loss policy and say, this seems like a particular situation where there is a hard gap. And by hard gap, I mean there's something where the actual provision within the plan notes that based on X circumstances, the claim would be payable under the plan. But due to a hard gap, unfortunately, the claim would not be reimbursable by the stop loss. So we can take a look at those facts, take a look at those materials at the outset, and provide an opinion and analysis based on that for the plan sponsor to use when they're making their claims decisions. Next is plan document assessments. So this is a proactive assessment that we can perform for the various groups, and there are 3 different levels, 3 different opportunities, and just because a plan had been reviewed in the past doesn't mean that it shouldn't be reviewed year after year. So we're in a constant state of evolving rules and regulations and modifications, and even more than that, the recommendations that FEA is coming up with from our experience, industry knowledge is evolving as well. So there's going to be continuing opportunities to save money and contain costs. So we want to make sure that every year we're taking advantage of all those different opportunities. So quickly, when it comes to these 3 different levels, and under ICE, all of them would be included. It would just be up to you or the group to decide which one would make the most amount of sense for the scope of the project that you're looking for. The level 1 review is an ACA or healthcare reform review, whatever healthcare reform looks like in the next year or so. So this is where we're taking a targeted approach, taking a look at the plan materials to make sure that as the rules currently stand, are there any compliance concerns or considerations that need to be addressed? Are the out-of-pocket maximums within the rules, within the guidelines for those limits? Are there certain provisions or limitations on benefits that may be contrary to what ACA allows you to establish within your plan? During that level 1 review, we're taking that targeted, limited approach to make sure that we're only providing you the information that you're looking for, which will be very useful as we know these rules and regulations are continually changing. So if we know that a new regulation is coming into place, this will give you the opportunity to have us take a look at that particular plan document with an eye for that particular compliance concern. Next is level 2. So this is where we're stacking on, in addition to the healthcare review or the ACA review, we're going to do a compliance review under ERISA as well. So this is a little bit more robust when it comes to the types of review and areas within the document that we're looking for. So for example, if you have a group that is looking for their documents reviewed for ACA, but also they have this new document, it's a new SPD, and they're a little bit concerned that maybe the provisions within this plan or this summary plan description aren't necessarily meeting the requirements under ERISA, send that to us. We can take a look at that. We can target those 2 areas, ACA and ERISA compliance, to see if we can point out any potential areas or concerns that might need to or might benefit actually from a revision, so we can identify the potential exposure that might exist for the group so they can be sure to address that and make those particular modifications if necessary. And last but certainly not least, when it comes to the levels of plan doc assessments, is level 3. And this is the most robust review when it comes to the plan document assessment. So we're stacking on level 1, which is the ACA review, and level 2, which is the ACA plus the ERISA review, and adding in the cost containment analysis as well. So in addition to looking for those basic compliance opportunities, we're taking it one step further and saying, not only are we going to ensure that this document has met from our standards and outlining the different compliance considerations, but are you doing all that you can to contain costs? Are there opportunities to put in new provisions, new benefits? Are there concerns when it comes to, for example, how the discretionary authority language is being added in the document? Are there exclusions that you're not necessarily taking advantage of that you should? Are there other areas within this document that could benefit from a potential update? The commentary from that assessment in the level 3 full evaluation assessment is really going to provide you the details for what we can do, how we can assist, the commentary we can provide for making sure that that plan is armed with all the ammunition possible from a compliance perspective and also a cost perspective. So they'll know exactly when it comes to the upcoming plan year, what can they do. You'll have our commentary, and you can use that commentary to discuss when you're actually making those plan changes. Next is the FIA certification. So this is an opportunity where we can take a look at, it's almost like a report card. So we have identified quite a few areas where we're looking to ensure that certain items have been addressed. ERISA compliance is one of them. Making sure that from our perspective, subrogation is important. Is there really great, strong subrogation language that maximizes the plan's recovery rights? We're looking at this report card of different items and certifying that that document, as presented to us, is falling within the guidelines for all of those areas on the report card as we've identified them. So it really kind of gives you a quick check. Instead of getting a multiple-page assessment, you're getting a quick guide, a quick check-in, like going to the doctor's visit for a visit, just to check to make sure that everything is crossing the I's and dotting the T's. So that is a good opportunity for someone who just wants a check-in based on certain parameters and certain items. And last, under the claim review/assessment piece, is the gap-free analysis. So quite a few years ago, this actually started, we were talking about mind the gap. I'm sure everyone has seen those signs, especially if you've ever ridden the tube in London. There's signs that are always reminding you to mind the gap, to mind the gap. Make sure that you're stepping over the hole or over the gap when you're getting onto the tube in London. So this was what we're trying to convey here. So for the gap-free review, it's really our opportunity to make sure, and this, like I said, started with the stop-loss policies. Between the plan document, we're taking a proactive approach so we can hopefully prevent any sort of issues from arising later on. We'll take a look at the stop-loss policy, we'll take a look at the existing plan materials, and we can compare the two to say, what is the opportunity for risk here? What's your exposure? Is there a potential where the plan says that we are going to only exclude felonies, but maybe the stop-loss policy says they exclude misdemeanors and felonies? That creates a gap between the plan and the actual stop-loss policy. So we'll perform an analysis and a review of those materials and identify those potential areas where the plan could be exposed or where there could be risk. And just in the past couple of years, we've realized that there's a lot of continuation of coverage leave of absence provisions that maybe aren't necessarily only contained within the actual plan document. Maybe employers have a really comprehensive, especially considering the employer mandate and the attention that has been receiving. Employers have made the decision to, instead of put information as comprehensive as possible within their actual plan materials, they outline everything with their employee handbook. So they're including benefit information, eligibility information, information about leaves of absence, and in addition to that, how you can continue coverage under your plan within the employee handbook. And they're not necessarily making those same modifications and adjustments to their plan materials. So in that circumstance, a gap review is going to be necessary, particularly for those types of individuals who are out on leave, maybe due to a medical condition. You need to make sure that if there is a leave of absence, which is an employer responsibility or an employer obligation, that also allows or grants the employee the opportunity to continue coverage, that is outlined for in the plan document as well. So as part of this gap review, when we're looking at the handbook and the plan materials, will help rectify and reconcile those differences that might exist between the actual plan document and the employee handbook as well. So there's the opportunity to revise and to revisit and prevent any potential issues that could arise along down the line from not having those materials that are cohesive together. All right, let's talk about third-party contract analysis. Want to flip ahead, Kelly? Great,
technical difficulties. There we go.
Okay. So in addition to having the claim review and the plan doc assessments, we're also looking at any sort of third-party contracts that might exist as well. So if you're receiving some type of agreement, some type of arrangement, and you want it to be reviewed just from a perspective of, based on your industry experience, can you provide me some commentary, feedback, or maybe you're getting pushback from some attorney who wants to modify an existing agreement, can send that all over to us. We can take a look and provide our opinions and commentary about what they're trying to change, or at least provide you with ammunition so that you can respond to those types of questions and be armed with the best potential response so that you can protect yourself and protect your groups. So specifically, just to give you an idea of how we can assist and where we can assist, here's a laundry list of the different types of agreements, but the Administrative Services Agreement. So, for example, maybe you have one in place, but maybe you're not sure that it's as strong as it could be. Maybe there's other opportunities where you should be delegating responsibilities or more clearly defining the roles between what the TPA is doing versus what the plan sponsor is doing when it comes to those obligations. Is it clear about how fees are being set up? Also, is it clear, maybe you're looking to add a new service. What do you need to add within the Administrative Services Agreement? Send it to us. Give us the opportunity to review your existing ASA, or maybe to make modifications based on a new service, new opportunity, new venture that you're looking to add as an offering for your groups. So give us that ASA. We can always take a look at it, look for opportunities to improve or modify some existing language, or if you're running into a situation with, like I said, an attorney who is maybe arguing about a particular provision, you want to have a second set of eyes take a look at it, you can send that over to us as well. Also, business associate agreements or BAA HIPAA agreements. If you are looking for someone to take a look at the existing agreement that you have in-house, or if there's requested modifications that you need assistance with, you can also send those to us for our review. We can take a look and provide our commentary. Also, network agreements. So those are pretty common for us to take a look, whether it is a PPO or PBM agreement. It doesn't matter. Feel free to send those over to us. We can provide commentary notes about if there's certain provisions or exclusivity clauses or something that could present a potential concern or something just to be aware of. There's prompt payment rules. You can send those over to us. We can take a look. Obviously, getting the actual provider agreements is a challenge, but when it comes to the network agreement itself, you can send those over for our commentary as well, even prior to being engaged with that actual network or after you've already engaged and have that network in place. You can send that to us. From a stop-loss policy perspective, so if maybe you have existing stop-loss policies, you're not necessarily looking for the actual gap review piece of it, but you just want us to take a look at an existing stop-loss policy, provide some commentary, some notes. Maybe this is actually before that policy has been entered into between the carrier and the group. You can send that over to us to take a look at that as well. And any other sort of vendor services agreement that might relate to the actual services that you're offering. So saying that you're looking to engage another company to help offer a new program for the benefit of the plan participants. You're not sure if the terms make sense or if it creates some potential concerns or problems and you'd like another set of eyes to take a look. Send those over to us. I think this was a long way of saying if there's an agreement that you are looking or being asked to engage in, commentary that you're not sure on, feedback that you're receiving that you're not sure how to adjust, send it over to us, and under ICE we can take a look and see how we can assist and provide you with that commentary so that you can be better armed to address the particular situation. All right, let's turn it back over to Kelly.
So how do you take advantage of these services? Like Jen said, you obviously have many things that you can reach out to us about. So we have set up dedicated ICE emails for each of our ICE clients. If for some reason you can't remember what it is, and you were a client prior to that, you can always send an email to PGC Referral, or you can contact me directly or Jen if you have questions and you can't remember exactly what your email address is. But everybody should have an email address that has essentially the name -ice@fiagroup.com. Again, if you have any questions, feel free to reach out to us and we can definitely give you a reminder of what that email address is if you forget. The FIA group will acknowledge the questions. Our intake team, no doubt many of you have talked to both of them, are Victoria Pace and Andrew Fine. They will acknowledge receipt of your question and give you an expectation regarding a turnaround time, response time. And if we need to define the scope, clarify a question or something like that, you'll get an email from them looking for either more information or clarification regarding exactly what the project is and what you're looking for specifically. We do have kind of standard response times that we generally look at with respect to the regulatory compliance and consultation. Generally about 6 business days. For the claim reviews and plan doc assessments that Jen spoke about, it's about 15 to 20 days. And then third-party contract reviews about 10 to 15 business days. We're happy to help in any way we can. If for some reason there's an expedited request, just let us know. Let us know if you have some other specific turnaround time in mind based on a client meeting or something else that's going on. If somebody's leaving for vacation, just let us know. We'll definitely do our best to accommodate, and we'll work with you to make sure that we're all on the same page with when you'll get the final product back. So our next slide that we have here is the ICE statistics for 2018. So this is just 2018 right now, and by the numbers. I'm sure it's not really a surprise to anybody, but kind of the biggest bucket that we have is our regulatory consultation. It obviously covers a very, very large array of different things because there's so many different regulatory requirements that we're looking at right now. So by far, more than 75% of the questions that we get and requests that we get through ICE are regulatory in nature in some way, shape, or form. The next largest kind of chunk here is the plan document assessments. We get a fair share of those through the ICE requests. And then close to that is the stop loss gap reviews, which is, again, like Jen said, it's been a service of ours, a signature service for kind of a long time. So for our clients who've been around for a while, you're familiar with this and you've heard about it and you know to request it. The handbook gap reviews are relatively new. We've only been doing those for probably a little over a year, maybe 2. My timeline of events may be a little skewed, but we're not getting as many of those. And then third-party contract reviews is about the same. We get, contracts from time to time, the ASAs, PPO agreements, PBM agreements. Please send those over to us because, as you can see, those areas aren't necessarily as highly utilized as the regulatory consultation. And for obvious reasons, your stop loss contract is your stop loss contract for a full year. But whenever that group changes stop loss contracts and is looking to another carrier, like Jen said, we're happy to look at a sample policy for the new carrier to be proactive and identify any potential areas of concern. So with that, we can move into our case studies. And our first case study is about Section 1557, and I will turn it back over to Jen.
Great. Okay, thanks, Kelly. So Kelly and I are going to go through a couple of actual real-life case studies, situations that we had encountered from some current ICE clients. And we wanted this to be an opportunity to share with you some of the stories that we have encountered and also to give you an idea that these are the types of things that we expect for you to reach out to us and for us to be able to assist. So Kelly mentioned 1557. 1557 is an area of the law under ACA that has received a lot of attention. The law is continuing to evolve, and there are particular industry trends when it comes to how certain individuals are addressing or dealing with 1557. And as we all know, there is a nationwide injunction that has been issued by a judge in Texas on particular pieces when it comes to 1557. So that leaves a lot of us in limbo when it comes to how are we supposed to address this? How are we supposed to accommodate, or these plans, how are they supposed to accommodate 1557 if they are receiving this federal assistance? So that was exactly the situation that arose here. So due to this evolving law, the changing landscape of 1557, we had a particular client who reached out to us and wanted to know what their particular risk or exposure could be if they were excluding the surgical and the non-surgical transgender services. So we've talked about this before, but in general, when it comes to services that may be available under the 1557 umbrella for individuals who are suffering from a gender dysphoria diagnosis, there's different categories of treatment. So we went over the different opportunities, whether there is the first umbrella, surgical obviously is the broadest and the one that can be the most expensive, the most concerning. Another bucket is the mental health services, so the potential counseling or any of the procedures that would go along with the actual transition piece. And last but not least is the prescription piece. So there could be hormones or other types of therapies that could be relevant for someone who has a gender dysphoria diagnosis. So we know that the rule as it stands, minus the injunction, is that a plan who is otherwise subject to 1557 is prohibited from having a categorical exclusion on all of those particular services. So we discussed together the differences and the variances of what a categorical exclusion meant, and we're able to talk together and discuss the various interpretations that others in industry had, the conservative approach versus others who are taking a more aggressive approach when it comes to what it means to categorically exclude, whether it makes sense to have specific language highlighted in the document or to be silent or to have that exclusion. So it really was an opportunity for us to discuss 1557, the opportunities that could present themselves under that. And then we even were able to take it one step further with this particular client, because 1557 is not the end of the discussion when it comes to gender dysphoria. So there have been various administrative complaints and potential litigation when it comes to employees, even if the employer itself is not subject, or the plan is not subject to 1557, someone could argue that they are being discriminated against. And how is that being handled? Well, that's a situation that the EEOC is being asked to step in and to handle. So even if there is a situation where a group is not subject to 1557, there still could arise a complaint to the employer by the employer of some discrimination or discriminatory actions that had been taken by the EEOC, and having an EEOC investigation into that. So we explained all the potential nuances and considerations and the trends, so that after this conversation, not only were we able to share our industry experience as to how others were addressing this particular situation, but at that point, that individual, that client, felt comfortable knowing the potential risks of the decisions that they maybe or maybe not would decide to take. All right, I'll turn it back over to you, Kelly.
So our next case study, we're going to talk a little bit about ERISA plan changes. Part of controlling costs and, staying up with the times and making sure we're compliant with everything is making changes to the plan document. They can be as little as changing a copay to as large as stopping covering some specific type of service, like no longer covering bariatric surgery or some other large category of services. And there's lots of considerations to take into effect. We get questions about plan changes quite frequently. Obviously, they take various different forms, and the gravity and the considerations may vary depending on exactly what specific type of change you're looking to make. For example, we have the ERISA rules about material modifications and material reductions. So material modification is actually not defined by ERISA. It just says that if the average person believes that this change to be significant change, it is a material modification. Similar to that with the material reductions, if you're reducing coverage in some way, shape, or form, and it's considered to be material to an average layperson, it's considered a summary of material reduction. So those are the specific ERISA requirements about plan changes. And what's interesting about ERISA is it's actually post-notification changes. Or post-notification of that change. So when you have to communicate a change to someone, the material modification is actually, you have to be able to provide that within 210 days of the close of the plan year. That's crazy. That means, if I made a change to my plan last year, I had until July of this year to tell participants that I changed it if the plan closed December 31st. It's a really long time. Material reduction is a little bit closer time frame. It's 60 days within the date of the material reduction happened. With that being said, one of the biggest considerations that I think plans don't necessarily take into account is that, we're not always proactive with making our changes. Sometimes we're a little bit reactive, or we've kind of missed that deadline for making sure the plan's in place for the next plan year. So while ERISA doesn't require a notification prior to a change being made, this doesn't necessarily absolve a plan of its ERISA fiduciary duties to clearly communicate the terms of the plan. So while these notifications are post-notification or post-change notifications, keep in mind that you still want to be as proactive with plan changes as possible. And I feel like the ACA kind of modified that a little bit by including the changes for SBCs. So if a change impacts the SBC and it's made in the middle of the plan year, there is a requirement to notify plan participants in advance of the change happening to the plan. So I feel like that may be where regulators went and said, hey, ERISA rules kind of don't make a whole lot of sense, so we're going to put in this ACA rule. So these timing rules are very important because it dictates when you have to give information to plan participants about your plan changes. There's also a significant other amount of considerations. Obviously, compliance is one of the big ones, but other ACA considerations may include if you're making a change and the plan is still grandfathered, if that change is going to cause a loss of grandfathered status. Some plans are still clinging to that grandfathered status for a little bit longer, as long as they can, as long as they can maintain, effective cost, control. That's okay. There's no problem with that. The rules definitely permit it. Other considerations to take into account with respect to compliance are HIPAA non-discrimination rules. This is the prohibition on discrimination on the basis of a health factor. Health factor can be a lot of things, but generally we see it in the context of diagnosis, a specific diagnosis or specific disease. So the focus when making benefit changes to a certain extent should be to make sure you're making those changes at the beginning of the plan year and to avoid a presumption of discrimination. There's also another angle for discrimination when it comes to Section 105H, which is the prohibition on discrimination in favor of highly compensated individuals. All self-funded plans are subject to 105H and should take that into consideration when they're making plan changes to make sure that that's not happening, that there's no discrimination in favor of those HCIs. Additionally, aside from all those regulatory considerations, we have other contracts to consider. When the plan makes a change to their plan document, the stop-loss contract almost always says that the stop-loss carrier must sign off on plan amendments in order to be covered under the stop-loss policy. So generally, if the plan is making a change before stop-loss will reimburse under it, stop-loss has to be notified and review and sign off on that amendment. So that can be key, especially if the plan is making a pretty large change. So that open line of communication is very, very important. Additionally, network contracts are something to consider. Jen talked about it a little bit before, but if you're making a change to the plan, you're changing your structure to add another tier of benefits. So you have an in-network tier and then a second in-network tier and then out-of-network. You have to take in consideration how that impacts the network contract. As it may, like Jen said, there may be an exclusivity clause where that may not allow you to utilize a second network, or there may be some sort of differential in place where the network requires the benefits for that specific network to be more favorable than other network tiers and or out of network. So there's a lot of considerations when it comes to making plan changes, and I think that sometimes employers lose sight of all these different things. So that's what we're here to kind of guide and help with, that if there's a very specific change that a plan is looking to make, we can help navigate what considerations they need to keep in mind, especially if there's some very nuanced, law or rule change that impacts that. So with that, I know that I said a mouthful, so if there's any questions, obviously reach out to us, but these are generally need to be reviewed on a case-by-case basis. And I will turn it over to Jen to talk about our next case study.
Great. Okay. So COBRAs, mergers, purchases, sales, acquisitions. So this is a common question when it comes to COBRA. So the consequences when it comes to COBRA and a non-compliance with the regulations could be substantial. So getting in front of these questions and trying to address them before they arise is going to be important. So we're continually receiving various types of questions about COBRA and timeframes and whether something or a particular circumstance would be considered a qualifying event. But another common question that we're starting to see is, what's the situation, what's the obligation, what are the requirements when it comes to COBRA when there is a merger or a purchase or an acquisition? So if a company is purchasing another company, what is the obligation of that purchasing company to take on the responsibility when it comes to any existing beneficiaries or individuals who are receiving COBRA under that current plan? What are the regulations? What are the rules? Was there any sort of obligation that they're going to have? So this can be a very confusing topic. There are a lot of nuances and various considerations based on networks or agreements or which plan is continuing or how the employees are being set up that needs to be continued. So in this particular circumstance, our first step was, since we all know timing is king, it's important to know what the timing requirements are, what the obligations are, because COBRA is only offered for a set amount of time. So we need to make sure that we're following with the rules, following within the guidelines when it comes to offering COBRA within that particular time frame. We're able to look at the agreements that had been provided, analyze the particular facts of that circumstance, and assist that entity to help make that determination about whose obligation it would be to continue those particular coverage for those particular qualified beneficiaries. So this is really important to not necessarily know that there's a set rule that will always come into play for every situation, because every situation is going to be a little bit different. Every purchase, sale, acquisition, merger, what have you, there might be a nuance or a specific consideration that could change the fact pattern a bit and how those individuals for COBRA purposes are being handled or should be handled. The moral of the story is that when it comes to a situation, particularly if it involves COBRA and it's unclear about how coverage or whether coverage should continue, please send those types of questions to us and we can take a look at those different nuances, those different documents and facts, and provide an analysis and commentary on what should be done, considerations or questions to ask if something is maybe silent or vague. This is going to help to avoid any stiff consequences or penalties that could arise from mishandling a particular situation like that. And I'll turn it back to you, Kelly.
So our next case study is about FMLA. And as we kind of briefly touched on earlier, over the last couple of years, stop loss has really seemed to pick up on the timing of leaves and continuation coverage as an area of focus when they talk about eligibility and payability of claims and reimbursement of claims under the stop loss policy. So they caught on to it a couple of years ago, and they've definitely held on tight. And it's very important, like we talked about with the gap reviews before, is that any type of leave or continuation of coverage or a leave where there is a continuation of coverage needs to be reviewed on a case-by-case basis because there's always unique facts. But more importantly, employers can get themselves in a lot of trouble when it comes to the timing of these situations because there's always a different fact pattern. Every employee has a different situation, has a different need when it comes to timing of leaves and how long leaves last and so on and so forth, and whether or not that leave even qualifies as FMLA. So the unique facts can very much change the outcome here. And with respect to FMLA specifically, employers have a lot of flexibility when it comes to how they administer their FMLA, especially whether or not it runs concurrently with other leaves and even with PTO. So it's important that employers have a policy and then subsequently apply that policy as uniformly as possible in all the situations. So when it comes to the plan specifically, this is important that it's documented in the plan document so that you know that FMLA is there, you know whether or not it's running in concurrence with other types of absence, basically to be able to show that the person is continuously eligible for the health plan. Because once you're unable to show that that person is eligible for the health plan, you can bet that stop loss is going to stop reimbursing. So in this specific situation, the employer didn't have a policy about exhausting PTO before FMLA. And in many cases, I think that's the case, but that's not always the case. There's some employers that have their policy set up differently. So the employee had exhausted FMLA, but had a couple weeks of PTO left, and the employer wanted to confirm that the individual was going to remain eligible under the terms of the plan document and that they weren't going to have any issues with stop loss because this person was definitely incurring claims while they were out on this leave. So we helped look at the plan language to determine, outline all the different eligibility parameters, make sure that the FMLA language was in there, make sure that the specific language about being an active employee and what that means and how often the employee has to work and whether or not when somebody was on PTO that even if it was after FMLA, that they were continuously eligible for their plan. So we ended up mapping out kind of a clear timeline of events because there was a lot of different dates that were impacting this specific situation. So we mapped out a timeline with our contact and gave it to the employer and helped them determine and outline when the person was going to be eligible, how long they were going to be eligible, and when coverage should end should the specific situation end up unfolding the way the employer thought it was going to happen. The other interesting piece and complexity that's been added now with the ACA is the employer mandate and these measurement periods, including specifically if you use the look-back method, that notion that individuals are locked into a stability period as long as they are still an employee, unless they fail to satisfy, the terms of the next measurement period, if they fail to meet the qualifications for how long, how many hours a week they have to work. So that was an extra added piece of fun with this one, is that the look-back method was very much being used. So we had to determine, when that stability period was ending, whether or not this person was going to satisfy the requirements of eligibility for the next stability period, and so on and so forth. So there's a lot of intricate little nuances and details when it comes to these things, especially with all these interacting rules. And it's very difficult sometimes to untangle everything and make sure that everything is in order. And as we all know, when it comes to stop loss, you take one misstep and stop loss is going to say, sorry about your luck, we're not reimbursing this. So it's very, very important that if you have some of these situations, especially when they get really unique and they have lots of different facets, to send them over to us and that we can help you navigate all the different rules and regulations and timeframes and make sure that the employer is keeping everybody on the plan when they are eligible and removing those that aren't eligible. And also, in addition to that, avoiding other penalties, because there's obviously very different penalties that apply under all these different laws that are interacting. So that is it for our case studies that we have. But next, like Jen mentioned at the very beginning, we have some tips and tricks that we've been developing here at FIA that we've been sharing on some of our other webinars that Jen will dig into now.
Great. Okay. All right. So we're all looking for opportunities to save money and contain costs. And there's different opportunities that can be taken advantage of. And we just wanted to share a couple of ideas, a couple of considerations. And obviously, if there is a particular circumstance or program that a group or that you are trying to implement, feel free, obviously, to reach out to us and we can set up a call and have a more in-depth discussion about it. But we did want to talk about incentivizing employees. So when it comes to containing costs and opportunities to do so, at FIA, we like to consider ourselves the guinea pigs. We want to try something out, try a program to make sure that it makes sense and to make sure that it's going to be successful. And based on our success, the way that we've implemented, the way that we've administered the particular program, we can find that as valuable experience and knowledge that we can impart on others so they can take advantage of those types of opportunities as well. So one of the things that we have done here by incentivize our employees to have some sort of say and also to save and contain costs, the big thing that we have done over the past year is to implement a DPC or a direct primary care program. And that gives us the opportunity to show real value to our employees by allowing them to have a personal, almost concierge doctor to address particular issues, particular concerns. There's a laundry list of different services that can be provided to those individuals who opt for that DPC. And we can see a real value, real savings, and having that for the employee to feel valued, to feel that they have something that is special, and also for the plan when it comes to containing costs. In addition to that, there are different ways that you can incentivize your employees. And this can be done through the plan or through the employer. And both of those are equally great options and opportunities, and neither should be overlooked. For an example, for the employer perspective, some of the things that FIA has done is we like to encourage discussion, to encourage individuals and employees to have some skin in the game. So outside of the plan, if there's an employee who is considering a procedure or is unclear about a particular medication and is looking to ensure that it's a high quality procedure or a drug, but also is cost effective, we encourage them to have a preemptive consultation with our HR, with the human resources team, to discuss their options, to discuss the opportunities that might be available to them. And by having those conversations, we're paying the employees, we're financially incentivizing them to have that discussion so that they are aware. We're in no way encouraging or pushing them to make a decision about their healthcare, but just educating them about the options that might be available to them, so they're enlightened, so they can have some skin in the game, so they realize the impact of the decisions that they're making. Another really successful program that we have implemented is our claim audit review program. So we have some particular language that will actually, and is designed to do so, to reward our employees for paying attention. Do you ever receive an EOB and just toss it out? Or instead, are you receiving medical bills, EOBs, any sort of documentation from providers? Are you reviewing it? Did you actually receive 2 services of what they're billing for? Did you only receive 1? Are there certain procedures, are the dates of service correct on it? We're encouraging our employees to actually look at their medical bills, to look at those charges, to see if there is a mistake or something that was overlooked when it came to the claims processing, or maybe it was an error on behalf of the provider. And by doing that and catching those mistakes, we're also financially rewarding our employees for the savings. So this is an opportunity for the employees to realize and to review their EOBs, not just toss them into the garbage and assume that somebody else is going to be financially responsible for them so they don't have to worry about it, but review it. Take that as an opportunity. Those are the types of programs at the employer level that we've actually been able to implement to get our employees excited about their healthcare, to make those informed decisions so they are aware of how this can have a bigger impact on our plan as a whole. In addition to the employer incentives that we're offering, there's also some plan incentives that we can put into place. So as a quick example, we wanted to encourage, when relevant, when applicable, the use of generics over brand name drugs. So in order to do that, we decided the best way to do that was to decrease the copay that would be applicable for certain generic drugs. And financially, by making that change to our plan design, obviously ensuring that it was not going to create any problems with any other agreements that we had in place, that is going to incentivize people to look, ask questions, because it's going to financially be beneficial for them to have a $0 copay instead of a $150 copay, for example. Also, we like to encourage the use of certain urgent care facilities instead of going to an emergency room at a hospital. So obviously, if there's an emergency, we always want our participants to go to the emergency room and seek the care that they need. But if there is a circumstance where an urgent care can take care of a stitch or take care of a particular situation, instead of having to go to the emergency room or waiving that copay, we're encouraging those employees to actually do an assessment of their condition, to do an assessment and to have the opportunity to save money if that particular condition warrants going to urgent care instead of going to the emergency room. So there's lots of different opportunities that you can take a look at your current plan design, your current structure. How can you incentivize employees to make a good decision, to have some skin in the game? And one of the ways that we have found that is by rewarding them for making those smart choices. Next on the agenda, or I should say last, is implementing new programs. So when it comes to a new program, there are lots of reasons and considerations when you're trying to put a new program into place. And along the way, we can assist, FIA can assist when it comes to the initiation, implementation, and the maintenance of those types of programs. And by that, I mean, if you are contemplating whether a new program would be beneficial for your particular plan, but you have maybe a high deductible health plan and you're concerned about the potential impact that having this program in place and the consideration for having that HSA component, what would the impact be? Maybe you want to have an analysis. Maybe you want to have a discussion. Those are types of questions that we can assist. Or maybe you have this new program and you've been provided some specific language. Maybe you need to have somebody review that language to see if that actually would align with the current provisions, if it's not going to create any problems. Maybe you want to have a foreign travel program, but you need us to review and provide commentary on certain areas of the plan that you might need to modify. For example, if you put in a foreign travel program, you probably need to eliminate or remove the foreign travel exclusionary document, or at the very least, modify it. And also, we can kind of walk you through the various considerations that might need to be contemplated when putting these programs in place. So, is there a conflicting network agreement that might come into play, something that you might need to have a conversation about. What about timing? Kelly spent a little bit of time talking about that case study when it comes to the ERISA rules about what are the requirements and obligations for notification. Are there certain timeframes that must be met and abided by when it comes to distributing these changes and making these notifications? Would by making this change at a mid-year as opposed to the beginning of the plan year create any concerns for discrimination? And also stop loss. What's the consideration of stop loss? Are there requirements when it comes to notifying them? If I'm adding a new program that's going to create cost savings, you'd think that stop loss would be excited about it, right? Because everyone's going to save money. But there could be requirements and obligations in place when it comes to the notification and the implementation of that particular program. So obviously every program is going to be a little bit different, but we did want to take this opportunity to let you know that these are the couple of things that we have seen that individuals are looking to take advantage of, maybe incentivizing their employees or putting these new programs in place. And we want you to feel comfortable to reach out to us and ask us these questions and see how we can assist and provide additional commentary on those. And I'll turn it back over to Kelly for talking about our kind of next steps. But we did want to remind everyone, too, that outside of this webinar, we do have podcasts and blogs and vlogs, which is a video podcast. So there's lots of different topics and areas and things that we are discussing on the regular. So there's a lot of different opportunities to hear us, engage with us, and ask us questions outside of just our webinars. All right. I'll give it back to you, Kelly.
Well, thank you, Jen. So we wanted to thank everybody for showing up and taking a little bit of time out of your afternoon. I know this is a crazy busy summer. Everybody's on a vacation or traveling, and there's still conferences going on. But we do want to thank you for showing up today. We will send a copy of this webinar with the slides and recording to everybody that is all of our ICE clients specifically and everybody that's in attendance. As our shameless plug, like we always do, our next free webinar for all of our clients is on August 14th. I don't think we have a topic just yet unless Jen's got some super secret insider information, but more on that to come. To register for that, you just go to our website and click on the registration link. And if you have any questions, concerns about ICE in general, how to use it, one of these services we talked about or one of the specific consulting matters we handle under the ICE umbrella sparked interest, you have a situation happening, definitely reach out to us with any questions you have. And like Jen said, we'll figure out how we can map out and best assist with every different thing that you have. So thank you again for attending. And Jen, I don't know if you have anything else you want to say, but give you the opportunity.
No, I
final words.
That's it. You covered it.
All right. Well, that is a wrap then. And thank you so much, everybody, for attending. And we look forward to continuing to work with you.